Yes, am I audible, Dhruv?
Yes, sir.
How have you been?
And sir?
How have you been?
Sir, good.
Yeah. So, Dhruv, we'll be starting with specific relief act. Did you attend earlier lectures also on specific relief act?
No, sir, my exams were there in the previous month.
So, when I talk about specific relief act, now this is a very important legislation. Reason being, A, it is one of the most important parts of civil law. And when I talk about the specific relief act, you should remember that in most of the civil matters, specific relief act is, remedy is available. So when I talk about specific relief act, major amendments have been done in 2018. And if you see the BEAR Act, you will see normally there are 8 remedies in specific relief act. So if I broadly tell you, there are around 8 remedies, 8 reliefs we call it in specific relief act. So these reliefs are very, very important. And when I talk about these reliefs, there are different categories to this. So the first relief, if you see the BEAR Act, is basically the possession of specific immovable property. So when I talk about specific immovable property, I'm talking about section 5 and 6, right? Moving further, we have possession of movable property. When I talk about movable property, I talk about section 7 and 8. Further, we have a relief for contracts by virtue of sections 9 to 24. Next, we have rectification here by virtue of section 26. Then we have recession by virtue of section 27 till 30. Then we move on to cancellation. When I talk about cancellation, I'm talking about section 31 to 32. Last but not the least, declaration, which is very, very important part of specific relief act. So when I talk about suit for declaration, I talk about sections 31 till section 33. And last is the preventive relief, which we call injunctions. That is section 36 to 42. So basically, there are 8 reliefs and specific relief act we talk about. And before moving further, you should know that specific relief act is also based on law of equity. As I've told you in one of earlier lectures, that specific relief act in India, we have court of law and court of equity is the same court. But when I talk about England, we have different courts of equity and different courts of civil law. So let us first go through the Specific Relief Amendment Act. Now, this amendment was a major amendment which has taken place in 2018. So if you open up your BEAR Act, let us talk about the important amendments which have taken in this act. So first, as you are aware that this act earlier was only available to India except Jammu and Kashmir, but most of your acts now are applicable to the to even to Jammu and Kashmir also. So this act first is basically the title, short title and commencement. So when I talk about short title and commencement, now you should be aware that this act is applicable. It's in whole of India, right? So earlier it was not applicable to the states of Jammu and Kashmir, but with the Reorganization Act of 2019, sections 95, 96, and fifth schedule, table 1. This is effect with effect from 31st October 2019, specifically factor is applicable to it. So you remember even in when I do with you Contract Act also, it is also applicable because Reorganization Act came in 2009. By virtue of Reorganization Act, your most of the civil law subjects, especially Transfer Property Act, Sales of Goods Act, Indian Evidence Act, Specific Relief Act, Registration Act. Now they are by and virtue applicable to hold. So this was the first amendment. Second amendment was very important amendment of Section 6 in Specific Relief Act. So when I talk about amendments, you should know these all important amendments because they are very, very important before reading the Specific Relief Act. Because now you will definitely see there has been sea change in Specific Relief Act. Why there has been sea change? Earlier, you see, specific performance of contract was only under the discretion of it. Now, courts have made firm rules, courts have laid down parameters in which specific performance of contract is granted and only exception is being created. Earlier, it was totally entirely at the discretion of the court. So, Section 6 of the old act has also been amended because in Section 6 of Specific Relief Act 1963, after the words he or any person, they are also including legal representative through whom he has been in possession or any person shall be insulted. After Section 6, there has been amendment. There has been substitution of Section 10 altogether. So now we have new Section 10. So new Section 10 of the new act will be substituted. So it says specific performance in respect of contracts that should be enforced by court. Exceptions are there. Exceptions are carved in Section 11, Clause 2, Section 14, and Section 16. So basically, this amendment is very vital amendment because in this Section 10, it says specific performance of contract shall be enforced by the court. Earlier, what was there? Earlier, if you see the old Bear Act of 1963, what was the old enactment of this particular section? So before that, it was always the discretion of the court. If I may read, the old provision of Section 10 said cases in which specific performance of contracts are enforceable. So it said, except otherwise provided in this chapter, the specific performance of any contract may, in the discretion of the court, be enforced. So here, earlier it was the discretion of the court. Now it is mandatory. It is shall. Shall has been substituted. After Section 10, you go to amendment of Section 11 also. Section 11, here also, the discretion of the courts has been substituted by contracts shall be substituted. After that, we have a new substitution of Section 14. So, Section 14 has been totally substituted by enacting 14A, B, C. So, when I talk about Section 14 in particular, you see, it says contracts not specifically enforceable. So basically, Section 14 is basically an exception where contracts which cannot be specifically enforced. So the following contracts cannot be specifically enforced. So you will, when we go through Section 14, we will come to 4 categories: A, B, C, D, and eventually, then there was a new section, Section 14A, which has been added by the amendment. Now, 14A provided the provision for the experts. So earlier, there was no provision of the experts to engage in the experts. Now, by virtue of Section 14A, there is engagement of experts. Moving further, after 14A, we even look into Section 15. Now, again, Section 15, after Clause F, so FA has been inserted. So why FA talks about limited liability partnership. Now, limited liability partnership was not in existence before. So after this amendment, that has been inserted by virtue of FA of Section 15. Moving further, we have amendment of Section 16 also. So in Section 16 of the Principal Act, following were added after clause A, who has obtained substituted performance of contract under section 20. In clause C, for the words who fails to aver and prove, the words who fail to prove shall be substituted. And moving further, we had amendment of section 19. Even in section 19, clause CA was added. It is similar to clause FA, which we have done earlier. Here also, we talk about limited liability partnership. Then again, we had another subheading under chapter 2, discretion and powers of court occurring under subsection under section 19. Now it says, subheading says, substituted performance activities. So substitution of new section 20 has been a very, very important amendment by way of 2018 amendment of Specific Relief Act. So 2018 amendment substituted new sections, section 20. Now, section 20 of the, when we read about substitute performance of contract, so it has been added. So we also see 20A, 20B, and 20C. So this all has been substituted by the new amendment of 2000. Moving further, there was amendment of section 21. So you can read from your Bayer Act, section 21, either in addition or in substitution, the words in addition or shall be substituted will be inserted. So amendment of section 25, Arbitration Act. Now they talk about Arbitration Act of 1996 shall be substituted. At the end, we have amendment of section 41. So in section 41, clause HA was added. And last but not the least was the new insertion of the SecJu. So after part 3 of the Principal Act, the SecJu shall be inserted. So these were the important amendments of 2018, which you have to bear in mind. So now moving further, now first let us do the definition clause. I have already told you that in most of your Bayer Act, section 2, by and large, is the definition. So in section 2, you will see there are different definitions. What is the meaning of obligation, settlement, trust, trustee, and it also says the last, all other words and expressions used herein, but not defined, and defined in the Indian Contract Act, have the meaning respectively assigned to them in that. So basically, Contract Act has to be read in specifically for Act also, where you find the terminology and which is not described in specific fact, you will turn to Contract Act and you will take the meaning as assigned to them in the contract. So let us now start with section 4. So what is section 4, Dhruv? Read.
Specific relief to be granted only for enforcing individual civil rights and not for enforcing penal laws.
Yes, read further.
Specific relief can be granted only for the purpose of enforcing individual civil rights and not for the mere purpose of enforcing a penal law.
So if you read this section, you will come to know the specific relief act is applicable only to individuals having civil rights, and it is not enforceable in penal law. So here we need to keep in mind that we are not talking about criminal law strictly as per Indian Penal Code. Now, there can be some circumstances. For example, uh, you know, when we say there is a wrongful death of a person, we normally talk about law of torts, right? Then one more example comes in my mind is when we read Hindu Succession Act. You will find there is one section 25 of Hindu Succession Act which says inheritance. The person who comes by who acquires by way of inheritance, that person will not be that person will be disqualified if he is a murderer. So here you should also remember Indian Evidence Act. If I talk about Indian Evidence Act, you will when you will go through, you'll find there are few sections which talks in what respect the criminal cases are relevant in civil cases when you talk about the criminal behavior of a person. So all these aspects you have to take into consideration. Now always remember, I told you there are 8 reliefs in specific relief act, but always remember this specific relief act is not exhaustive. It means if you have any other remedy and it is not defined in a specific relief act, what will you do? You will go to section 9 of civil procedure code. So if any remedy is there and that remedy is not defined in specific relief act, what is the general law remedy? File a case under section 9 of civil procedure. This is a very, very important information which I am sharing. So uh, always remember this act is not exhaustive. So, and whenever I talk about other civil remedies, anybody can file a suit under section 9. Now, I will be talking about the first relief. When I talk about the first relief, what will I talk? I will talk about chapter 1 and I will discuss here with you section 5 and 6. So let us talk about section 5. So read section 5, uh, Dhruv, read section 5.
Recovery of specific immovable property. A person entitled to the possession of specific immovable property may recover it in the manner provided by the Code of Civil Procedure 1908, 5 of 1908.
So what do you understand by this section? Give your inputs on this.
Like a person who is having possession of specific immovable property, he may, if not under the specific relief act, it can go to the civil procedure code and get
So
the possession of
basically,
it.
section 5 is what is section 5? Section 5 is the general code remedy. It is the general code remedy. What is the general code remedy? Obviously, you can file your case under section 9 of civil procedure. That is the general code remedy. So, so normal remedy is under section 5, which is regulated by CPC, which has been there since long. So section 5 was a normal remedy. What was there? Uh, anybody wanted to claim a relief? Hold on. So anybody wanted to claim a relief? So specific relief act came in which year? Yes, Dhruv, it came in which year?
1963.
And CPC was in which year?
1908.
So earlier, what was the normal remedy? Normal remedy was under CPC, right? So the aggrieved party always had a remedy under CPC, that was a general remedy. So eventually, specific relief came in 1963. And when I talk about 1963, so basically it is available under specific performance of contract. So let us read section 6. So section 5 is a normal remedy. Now let us go to the specific relief remedy which is provided under section 6. Read section.
Sued by person dispossessed of immovable property. Clause 1. If any person is dispossessed without his consent of immovable property, otherwise done in due course of law, he or any person through whom he has been in possession or any person claiming through him may by recover possession thereof, notwithstanding other titles that may be set up in such suit. Clause 2. No suit under this section shall be brought after the expiration of 6 months from the date of dispossession or against the government. Clause 3. No appeal shall lie from any order or decree passed in any suit instituted under this section, nor shall any review of such order or decree be allowed. Clause 4. Nothing in this section shall bar any person from suing to establish his title to such property and to recover possession thereof.
So when I talk about section 6, applicability of section 6 is possible only the conditions are given here thereafter. So what is the first condition? Plaintiff seeking the remedy must be in possession of immovable property. So the first condition is that the person seeking possession the person must be in possession, seeking remedy must be in possession of immovable property in question. Second condition is the defendant must be the person who has dispossessed the plaintiff, right? Defendant must be the person who has dispossessed the plaintiff. Third condition, if you see your Bear Act, it says the dispossession must relate to in, right? Fourth condition says that dispossession must relate to immovable property. Fourth condition says dispossession must have taken place without the consent of the party, that is the plaintiff. So therefore, dispossession by defendant is with the consent of party. So what is the so when the dispossession is with the consent of the party, then section 6 remedy is not available. It is only available when the dispossession is there without the consent of. So these are the very, very important conditions. Further, it says that it should be in that dispossession should not be in accordance with law. So you cannot claim remedy if you have been dispossessed lawfully. So this remedy is only available if you are dispossessed unlawfully. Next condition says this relief is only available against private person and not against government. This is also very important that specific relief that when I talk about specific remedy of section 6, this is available against private person and not against government. Moving further, it says when we read section 2 and clause A, it lays down the limitation. What is the limitation here? It says no suit under this section shall be brought after the expiry of 6 months from the date of disposition or against the court. So it says this relief is only available against private person, not common. Restrictive period of limitation within which relief must be sought, that is 6 months. Now, this 6 months has to be calculated from the dispossession which took place or knowledge thereof, whichever is later. So, this has to be kept in mind. Further, it says, so when I talk about these conditions, these are strict conditions and it has to be complied. They all have to be read together so that your suit comes under the purview of section 6 of specific performance. So I give you one preposition. Let us suppose in one case, a trespasser entered, right? And person is person in possession sent him a legal notice, which was done within 6 months. So 6 months were over. Meanwhile, notice given to parties and suit brought after 6 months. Now the question is, what did it entitle suit to be filed? Now here you remember that 6 months is calculated from formal filing of suit by plaintiff. Therefore, notice given within 6 months is not suit for the purpose of period of limit, right? So within 6 months, you need to file a suit. Because if you see, it doesn't say no notice, it only says no suit shall be brought into this section after expiry of 6 months from the date of disposition. All right. So this preposition which I have shared is very, very important. Another point which you have to keep in mind is the issue before court under section 6 is limited only to one point. That the fact that is the fact of possession and disposal. So ownership and all is not considered by the court at this point of time. We are only talking about possession and disposal. So it doesn't bar a true owner having a lawful title to file a suit of declaration if his title is questioned. All right. Or bars a real owner to file a suit of injunction against the person who is trying to dispossess. So here the role of court is restricted only of deciding on one single issue, that is dispossession of immovable property. It reflects summary nature of proceedings. So this is a very, very important input which you have to take care of. Next point you have to take care is the judgment of court and relief granted is limited and restricted. Only an order or a direction of restraining possession back to plaintiff. No other relief or remedy can be availed by virtue of section 6. And therefore, no claim. Now, there is one more term used in TPC. You see, normally when we file a suit, normally we also file an application of mean profits. Now, what is mean profits? Yes, Dhruv, what is mean profits? Tell me. So, mean profits is your homework. You will find it out. What is the meaning of mean? Now, last point it says no appeal. So remember, proceedings under section 6 are not subject to appeal or review, but revision is not mentioned. So normally revision is can be filed because the different views of the different high courts. So now the view of revision is not explicitly barred. Is that has been held by Supreme Court in one of the decisions, that is Vanita's case. So under normal remedy under CPC, revision is there. Here you should remember that revision is a remedy. Appeal and review is not a remedy, as it is mentioned in section 6, subsection 3. No appeal shall apply, nor any review of any such order shall be taken. Now, the next question which comes to my mind is whether the nature of verdict under section 6 operates as a res judicata. The answer is no. Why? Read the last fourth line section. What is subsection 4 of section 6 talks about? Read through.
Nothing is in this section shall bar any person from suing to establish his title to such property and to recover possession thereof.
So here you should remember that it doesn't bar a person to claim a remedy. He is the owner. Nobody can bar him from filing a suit of injunction also. So now you will do comparison of section 5 and 6 on your own. That is a general remedy. This is specific. Here in comparison, what will you mention? You will mention the conditions as has been prescribed under section 6 of specific. Am I clear on this?
Yes, sir.
Now, when I talk about section 6, I have to use the word immovable property. Now, what constitutes immovable property? Now, this topic I have already done in this detail when we were doing Sales of Goods Act, even in my early lectures of Specific Relief Act. So, what is immovable property? So, when I talk about immovable property, you see first the definition clause of Specific Relief Act. Dekho, whichever word comes, whichever definition you have to find, first and foremost, you have to see the Bare Act. And to see the section 2 nowhere talks about immovable property. Does it describe, does it tell you something about immovable property? Yes or no?
No, sir.
So, अब आप क्या करोगे? So you should always first see the rest of the statutes. Now, immovable property is not defined here. So you should always remember there is a this act you should all know, that is general clause. तो आप देखो इमूवेबल प्रॉपर्टी is also described in general clause that there is a detailed definition of immovable property in transfer property act. Then there is a very detailed definition of immovable property in registration act, that is section 2 subsection 26. So sales of goods act also defines it. So the best definition of immovable property, you go through all these provisions which I have told you, and then you will come to know what is a immovable property. For example, I may quote a question right across to you, whether fisheries is a movable property or immovable property. So this you will only come to know once you know the important uh, ingredients of immovable property. So this is also your homework. You should do on your own what is the meaning of immovable. So also after immovable property, you should also know the meaning of possession. So when I talk about possession, you should always remember there are two kinds of possession. Yes, Dhruv, what are the two kinds of possession?
So, according to jurisprudence, there are two types: de facto possession and de jure possession.
So one is the corpus, that is the physical control, right? One is the other one is intention of eliminating others from taking physical. You will also read about the meaning of possession. So you should know what is a juridical possession, what is a, uh, physical possession. So this topic of possession, just go through it because it needs some kind of elaboration from my end also. So for today, I have told you the amendments. So all these topics which I'm telling you regarding immovable property and possession, this you just go through it so that in my next lecture, I'm able to elaborate on this. Am I clear?
Yes, sir.
So, ठीक है फिर है, and I'll update you about the next lecture. Okay.
Okay, sir.